Hello everyone, for today's Murphy Law Monday, I want to touch on a topic of what is a default and how can it apply or hurt me in court. Now, a default defined legally is basically just like the word sounds, is by default when the person who against a case has been filed does not respond, and the person who filed the case gets a default of what they requested. So, for example, if a party files for custody and child support and they serve the other party, the 30-day notice for when the other party has to respond is from the day that they were served. So if the clock ticks and 30 days have passed and they're both in the same jurisdiction, then the court or the plaintiff, the person who filed the case, can ask the court to issue a default. If a default is issued, the other party gets a little bit more time. They get another 30 days after the default is issued to respond. And if they don't respond, then the court gives, again, the other party what they want as a result of the defendant, the party against whom the case was filed, not responding. Now, I want to touch on this topic for a few reasons. What if you're on the other side of it? What if you got the paperwork, put it on the kitchen counter, and honestly just forgot about it? Or you wanted to wait until you saved up enough money to hire an attorney and you're in a predicament where today is the 30th day or today is the 50th day and you don't know what any of this means. You don't even know what a default is. Now, in a lot of instances, and depending on what type of case it is, if it's a family matter and concerning children and different issues like that, sometimes the court is a little bit more lenient on withdrawing or vacating. The legal term is vacating a default that has been issued against you. And like I said earlier, if the 30-day window has passed and they actually got the default, there is another 30-day window from the time that the first 30-day window passed and the day they get the default for when you have to respond. I've seen a lot of situations where, again, the courts are lenient to those persons who have a valid reason as to why they didn't respond. But if you are on the receiving end and you know you didn't respond to a case and oh shoot, 30 days have passed, you might want to give my office a call so that we can get the motion to vacate the default in a timely manner, because if you don't, then the default will be entered. And what that means is that you're going to have to explain to the court why they should vacate what they've already done. And in addition to not being timely in the first place, you're also not timely in the time period of when you had to respond. So the court has essentially given you more time than they normally would under circumstances. And unfortunately, court rules are very strict. They don't care who you are. They don't care if you do or do not understand what's happening. When you step into a courtroom and you don't have an attorney, you are essentially taken as if you are an attorney yourself and understand the evidence and rules of procedure that apply to your case. So I think it's important that if you were served or you filed a case, that you keep an eye on the clock, because the clock is ticking. And I just wanted to give you guys that tidbit for what a default is, how you respond, what's the process for it if you don't respond. If you're in need of legal services in the state of Maryland or the District of Columbia, please give my office a call, 240-493-9116 and www.amurphylegal.com.